Be ready. 5 seconds.
We hold that the prosecution has been able to establish beyond reasonable doubt that the appellant was the person who stabbed the victim during the course of the attack by the accused persons leading to his death. Stop. The criminal act of the appellant as the one responsible for homicidal death of the victim being established, we need to probe now whether such act would come within the ambit of section 300 IPC. Stop. Sections 299 and 300 thereof have to be read together, as culpable homicide and murder are closely related concepts. Stop. It is often said that culpable homicide is the genus and murder is one of species in that genus. Stop. All murders are culpable homicide, but not all culpable homicides are murder. Stop para. We find that the weapon used for the attack was a dagger, which is considered a deadly weapon. Stop. The weapon was carried by the appellant to the scene of the incident and not picked up from the spot. Stop. The victim was stabbed in his chest, which houses multiple vital organs of the body. Stop. There was no provocation from the side of the victim. Stop. The appellant and other co-accused had reached the place of occurrence with the intention to cause hurt to the victim, which can be seen from the fact that they formed an unlawful assembly armed with deadly weapons with the common intention to attack the victim and thereby put an end to the movement triggered by him to stop trade in illicit liquor. Stop para. The post-mortem examination of the victim revealed the cause of death of the appellant to be due to a wound on the apex of the heart. Stop. In his cross-examination, PW8 bracket, who conducted the post-mortem examination, bracket close, noted that such an injury can cause death within 5 minutes of infliction. Stop. The appellant's submission that only one of the 8 injuries sustained by the victim is grievous and the rest are simple and hence there is no intention to cause death, cannot be accepted after examining the facts of the case. Stop. In Stalin versus State, this court held that death caused by a single stab wound can also be considered murder if the requirements of section 300 IPC are fulfilled. Stop para. To summarize, the appellant participated in an attack on the victim, armed with a deadly weapon and stabbed the unarmed victim on a vital organ, causing his death. Stop. The conduct of the appellant is covered by both clauses 1 and 3 of section 300 IPC. Stop. The intention to cause death can easily be discerned from the conduct of the appellant and the nature of fatal injury inflicted, which in the ordinary course of nature was sufficient to cause death. Stop. Fulfillment of any one condition of section 300 IPC is enough to convict the appellant under section 302 thereof, but in the present case, not one but 2 conditions have clearly been shown to exist to nail the appellant for murder. Stop para. In conclusion, we agree with the High Court's affirmance of the conviction and find that the impugned judgment warrants no interference. Stop. The criminal appeal, accordingly, stands dismissed. Stop. The order dated 13th February, 2015, granting bail to the appellant stands vacated. Stop. We direct the appellant to surrender before the concerned court immediately but not later than 3 weeks from date to serve out the rest of his sentence. Stop.